What are the latest regulations for California landlords and California tenants? We are going to run through those for 2023. It's actually a pretty uneventful year, but we're going to share two important pieces of legislation for California landlords and California tenants, plus make sure that you haven't missed out on other important disclosures and updates from years past that unfortunately I find that many landlords have missed. Hey there, Christian Walsh, real estate agent with Wire Associates. We've been helping renters and landlords make sense of these crazy days, and we're here with an update for the latest 2023 legislation for California landlords and California tenants. And remember, we can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. And another important point is make sure you understand your local regulations for rentals. Landlords, you may find there's additional disclosures that you must give, and there may be additional regulations you have to follow. So make sure you join a local apartment association or landlords association, or reach out to an attorney in your area to understand your rights as a California landlord or California tenant. Let's take a quick run through a few things that not enough California landlords know that they're supposed to be giving their tenants. Here's an oldie but a goodie. This is the lead-based paint addendum. So this would be for any rental property, a house, condo, that is built pre-1978, so it's 1977 or older. There is a chance that there's lead-based paint in there. This form must be given to the tenant. The tenant is able to go ahead and test for lead if they would so choose, and the landlord must disclose if they actively know if there's lead in the unit. So it's important, anything 1977 or older for real estate, that this form is given by a landlord to the tenant. Another required disclosure for bed bugs, a landlord must give this to a tenant, and it outlines what a bed bug is and what steps to take in the event that a tenant believes there are bed bugs in the unit. You don't have to use this exact form. This is a sample of it, but it should include information like this. Another important one is the tenant flood hazard disclosure. Again, you don't have to use this exact one, but you should use one like this, and this is where a landlord would disclose if they know that a rental property is in a flood hazard zone. Both bed bug and flood hazard are relatively new forms to include. And this is a big one and a very important one. The Tenant Protection Act of 2019, also known as AB 1482. We've released other content on this. There's required language that a landlord must give a tenant whether a property is exempt or subject to AB 1482. I encourage you to watch our other content on it, but make sure you use a form that has the required language on it when signing a lease. And this is the newest of the required disclosures. This is from the California Department of Public Health, and you would use this particular disclosure, use this exact one. We have a link below so you can do that. And it talks about mold in a rental unit. It's required that a landlord give a copy of this disclosure to their tenants and include some ugly pictures, but this is the exact one that a landlord needs to give to their tenants. Here's another important one. It's from a couple years ago, but this is related to rent increases, and I still find that there's a lot of confusion out there as far as the amount of time that is required, the amount of notice that's required for a rent increase. This is AB 1110, and what this states is that any rent increases that are 10% or less, a 30-day notice is required. Any rent increases above 10% in a 12-month period are going to require a 90-day notice. A couple of quick important points. Obviously, the tenant has to be coming to the end of their lease or month to month in order to raise their rent. Another important point is rent increases above 10% would only be allowed on properties that are exempt from AB 1482. So I encourage you to check out that content where we explain exactly what that means. And don't forget, we're real estate agents. Make sure you reach out before you buy or sell if you're looking for a perspective from someone who understands landlord and tenant regulations. So one of the first important changes for landlords and tenants in 2023 is Assembly Bill 1410, and what this states is that a homeowners association cannot prevent an owner-occupied unit from having some portion of it rented out. So if the owner is living in a property that is in an HOA and they want to rent out a bedroom or two, An HOA cannot pass legislation, can't codify it to state that this person is not able to rent out a bedroom. So as long as it's owner occupied, that owner is able to rent out bedrooms. So this is an important change, and this will affect a few folks out there who are trying to make ends meet. Before you jump into doing this and becoming a landlord with tenants living in the unit with you, I encourage you to seek legal counsel to discuss whether this makes sense for your situation. And one of the other changes for 2023 is Assembly Bill 2559, which creates the Reusable Tenant Screening Report. This is completely optional for a landlord to accept, but in a nutshell, the legislation was created because tenants, when they go to apply for an apartment, often have to pay multiple screening fees to different landlords, especially if they're not approved at 1 or 2 or 3 different places. So this can add up. The Reusable Tenant Screening Report is an attempt to make this process easier and cheaper for actually both sides. So landlords will get standardized information that they can rely on. So it talks about what would be included in the report, and it's important things that a landlord needs: verification of employment, last known address, results of eviction history, if you're allowed to pull that in the area. It's going to have their credit score as well. This report could be helpful, and the fact that it's standardized will be good for landlords being able to get consistent information, and this will save money for tenants. The landlord is not able to charge a screening fee if they accept this, but they also can't be charged themselves for this report. So there's some savings there. There aren't costs they have to pass on. So this, we will see how the rollout goes, but this will probably be pretty slow because, again, it's not required for landlords to accept this. The truth is, the application process, anything that standardizes it and makes it easier for a landlord to make a decision with reliable information, that is going to make it an easier process for everyone involved. Make sure you get the latest and greatest on California legislation for California landlords and tenants by subscribing to our free weekly email newsletter, where we cover topics like this, plus market updates and a whole lot more that you're not going to want to miss. And let us know in the comments below what questions you have as a California landlord or California tenant. Check out this next video where we talk about AB 1482 and why it is so important in the state of California. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, and we want to hear from you.